This appeal was presided over by the President of the Court of Appeal, sitting with me and Walia J.A. I prepared the decision, which is concurred to by other members of the panel. The appellant was convicted of the murder of his lover and sentenced to death. He appeals against sentence. The respondent does not oppose that appeal. We have considered the facts of the matter, and we find that there were indeed a number of extenuating circumstances which warranted the imposition of a lesser sentence than one of death. We have reached the decision that the appeal against sentence succeeds, that the sentence of death imposed by the High Court is set aside and replaced with a sentence of 25 years in imprisonment, that such sentence shall run from the 25th of April 2023 and shall have deducted therefrom the period which the appellant may have been in custody awaiting trial. We hand down the reasons for the decision.
This appeal, the appellant was charged with the murder of a man whose cause of death could not be established by reason of advanced decomposition. I have penned this judgment with the President of the Court and Legislator J.A. concurring, and the decision of the Court is that the conviction cannot be allowed to stand. The following orders are made: the appeal is allowed and the conviction is set aside.
CHGB 213 of 23, and another.
My name is for the record, Morupisi'S, initials E.N. I pay for the respondent.
Yes, this was an appeal against the default award of damages by the registrar. I accept with my brother Morupisi'S J.A. and Froman J.A. and the decision of the court is that the award was not appealable, and accordingly the appeal is struck out with cost to the respondent. I hand down the rules.
I support cases.
CLCGB 037 of 24, Simba Mampori versus the state.
It's pleasure trust the court instructions of the appellants legally summoned.
Hearing for the state, the name is initials M.
This is an appeal against death sentence after the High Court made a finding that there are no extenuating circumstances. We considered the matter sitting with my colleagues, Habana High and Legorwe, acting judges of the Court of Appeal, we came to the conclusion that the finding by the court below that there were no extenuating circumstances to the killing of this 12-year-old child was proper, and as such, the appeal had to be dismissed, and the judgment of the trial court on whether there were extenuating circumstances or not was affirmed. These are the reasons.
CLCGB 061 of 24, Kamakolo Moretti versus the state.
Companies Malaysia, I appear for the appellants. My name is Defamation.
May I please support? My name is Anna.
Yes, in this matter, I sat with Dambe J.A. and Havana I.J.A. I wrote the judgment. The matter came before this court by way of referral in terms of section 15 of the Code of Appeal Act. The decision of the court is that the referral was incompetent, and the order of this court is that the referral is hereby struck out. I have now this.
CICGB 192 of 23, Silver Spear Pty Ltd and John Callis Hunting Safaris Pty Ltd.
Good morning, my lady and my lords. Pleasing this honourable court, I confirm my appearance on behalf of the appellant herein. My name for the court record is Juna, initial S. I hold brief for attorney Selelo, initials EO.
Quite accused, lady and lords, Car Hartley, initial J, and I appear for the respondent.
This matter concerns two adjoining pieces of property in Botswana's high tourist area, in which the respondent alleges that the appellant has been trampling across its property against the law and in violation of the trespass provisions, but the appeal concerned highly technical issues. I sat with my senior colleagues, Justice Garekwe and Justice Morupisi'S, and our conclusion, which is unanimous, is that the appeal is dismissed with costs.
As it is moved.
As the court pleases.
CICGB 012 of 23, Nimwam and Little Roof Trusses Pty Ltd and 3 others.
Please the court, I appear on behalf of the appellant. My names for the record are Masu initial S. The respondent is represented by Mr. Sikape, who has asked me to note the judgment on his behalf as well.
This appeal I sat together with my brothers, Mr. Perry J.A., Cameron J.A. I prepared the judgment. The appeal is dismissed with costs, and I hand down the reasons.
And the copy is
CICGB Cross Calvary and Body's Love Church in Zion.
This honorable court for the respondent holding brief for Mr. PKM. I appear on behalf of the respondent.
this appeal, I sat with Dambe J.A. presiding and Liduru AJA, and the decision is unanimous. It's an appeal that emanates from the decision of Antonio J. rendered on 5th August 2022, where he upheld the exception that was raised by the respondents and dismissed certain paragraphs in respect of an amended counterclaim, and also upheld the Order 33 Rule 1 application and granted costs against the plaintiff in reconvention in the matter. And the order of the court is as follows. The appeal is struck out with costs in favor of the respondents. And I hand down the reasons.
CICGB 010 of 23, Kosi Mohalakwa and the Northwest District Council and 2 others.
Conclusion for the appellant, would you proceed
For the first respondent, this will take initials youth, overrule for Moana
This is a unanimous decision of myself, Harabi J.A. and Dambe J.A. And the appeal concerns an application for a declarata and consequential relief. The decision of the court is that the appeal is dismissed with costs. And these are the reasons.
CICGB 015 of 23, John Brebner and Gaborone Lions Park.
For the respondent, cannot see initials.
This matter was authored by myself, sitting with Tebogo Marupi and Ngabinde J.A. The decision of this court is that the refusal by the court below of the application for rescission was proper, and the appeal therefore has to be dismissed with costs. And the decision of Dube J dismissing the rescission application is hereby affirmed. These are the reasons.
CICGB 034 of 23, Creative Business Solutions Pty Ltd and 2 others, and Citizen Entrepreneurial Development Agency.
for the respondent, Mr. Rekada Mareka, initials S.
This is an appeal in which my sister Namde J.A. presiding and my brother Tebogo Maruting and I said. The appeal concerns the grant of summary judgment by the Court of Appeal, the High Court. We have found that the appellants have established material facts which, upon consideration and proof in the High Court, might constitute a bona fide defense against the claim by the respondent. Accordingly, we have considered that the appeal should be upheld in favor of the appellants. Accordingly, the following order is made. 1, the appeal is upheld with costs. 2, The summary judgment granted by the High Court on 10 June 2022 is set aside and replaced with an order reading: 1. The application for summary judgment is dismissed. 2. Costs shall be costs in the action. 3. The matter is remitted to the High Court for hearing before a different judge. I hand down the judgment.
CICGB 02022, Tawana Land Board and Kaveto Kangumbe and another.
This is the honorable court for the appellant holding before PPLM here on behalf of the appellant.
Yes, thank you. In this matter, the appellant appealed raising a question of law whether the land tribunal had, at least at the time it made the decision, the power to rescind its own judgments. I sat in this matter with Harekwi J.A. and Luburu J.A. I prepared the judgment which is concurred to by my colleagues. The outcome of the appeal is as follows. A, the appeal is upheld. B, the decision of the Land Tribunal and of the High Court are set aside. C, the decision of the Land Tribunal is replaced with an order that the legal point raised by the Tawana Land Board is upheld with no order as to costs. 2, the application for rescission of the default judgment granted on the 14th April 2016 is struck out and the said judgment stands. D, each party to bear its own cost of this appeal. I hand down the reasons.
CICGB 083 of 23. We are from Mapika and Botswana Housing Corporation.
Court pleasing my lords and ladies, for the appellant Morupisi'S, initials PM.
This is the honorable court for the respondent, I am Damba, initials S.
This appeal was presided over by Mr. J.A., sitting with myself and Liburu A.J.A. The appeal was lodged in the backdrop of a ruling of the Quarter Court of 12 April 2023. The Quarter Court had upheld a point in limine raised by the respondent to the effect that the appellant was not entitled to raise commission on an attachment issued pursuant to a judgment that was set aside. The decision of the court is unanimous, and the order of the court is as follows. 1, the appeal is upheld with costs in favor of the appellant and as against the respondent. 2, the order of the court dismissing the appellant's claim with costs is set aside and replaced with the following order. 1, the plaintiff's claim succeeds and the defendant shall pay the sum of $2,340,000 to the plaintiff. 2, the defendant shall pay interest thereon at the rate of 10% per annum from the date when the payment of $72 million was made to date of payment of the said commission. And 3, the defendant shall pay the cost of suit. I hand down the reasons.
CICGB 04023, Ramasala Ryan Twaitile and Maipilo Homolemon Twaitile and 2 others.
For the first respondent, Defamation initially.
Court please, for the second and third respondents, try initially.
This is a unanimous decision of myself, Farouk J.A. and Elizabeth J.A. And the two legal issues were raised in this appeal. One, whether the appellant had locus standi, and secondly, whether he had disclosed a cause of action. The decision of the court, which is unanimous, is as follows. The appellant had locus standi to the second and third respondents. 2. The appellant, however, failed to disclose a cause of action against the second and third defendant, and this claim is therefore dismissed. And lastly, because there has been partial success by all the parties here, each party shall bear his or her own costs. I hand down the reasons.
CACGB 04421, Albert Montentema and 5 others, and Clement Cosima.
This is the court. My name is on the record, Morupisi'S. I stand in for Mrs. Kape for the appellant.
This is the Honorable Court appearing for the respondent, T. Rantau. I appear on a brief from my learned friend, Mr. M.M. Musu.
This is an appeal in which my brothers, Pronoman J.A. and Cameron J.A. said the matter concerned a declarator that was granted by the High Court in favor of the respondent. We have prepared a judgment which I have penned, and we have concluded that there is merit in the appeal. Accordingly, we have made the following order. 1, the appeal is upheld with force. 2, the order of the High Court dated 4 March 2021 is set aside and replaced with the following order. The application is dismissed with costs. 2, the rule 9 issued by the High Court on 14 October 2012 is discharged. I hand down the judgment.
The court please.
CACGB 10423, University of Botswana and 2 others, and the Homole Moradi Botswana.
Pleasing this Honourable Court, I confirm my appearance on behalf of the appellant in the matter. My name for the court record is Junior initial S. I also appear this morning to note the judgment on behalf of the Respondents' Counsel, Attorney Ms. J.
This matter concerns an applicant for a post at the University of Botswana who was offered the post subject to the university's satisfaction in regard to a medical examination in which the university refused to confirm the appointment, but the High Court granted an order setting aside the university's refusal and remitting the matter to the university. I sat in this matter with my colleagues, Justice Nkabinde and Justice Fruneman. We were unable to reach a unanimous decision. I penned a judgment in which my sister Nkabinde J concurs, in which we dismissed the appeal with costs. My brother Fruneman has penned a minority judgment in which he would have allowed the appeal with costs. I hand down both reasons.
As the court pleases.
CACGB 176 of 20, ATD Media Pty Ltd and 2 others, and Katangata Morupisi'S.
For the appellant, Junoi, initial L. For the respondent, Nalimet, initial B.
This is a matter in which the respondent instituted action against the media concerned for defamation, and in which the High Court found that the respondent had been defamed and granted the respondent damages of 200,000 pula. I sat in this matter with my sister, Justice Nkabende, and my brother, Justice Fruneman. The appellants sought to have the judgment of the trial court set aside on whether the respondent was defamed. The judgment of the court is that the respondent was indeed defamed. However, on the question of the quantum granted, which was, as I mentioned, 200,000 pula, the court finds that because the defamation related to an allegation that the respondent was petty in the exercise of his office in relation to the former president, President Khama, and did not allege grave misconduct bearing on his competence to hold office or on allegations of corruption. For those reasons, the court reduces the award of damages from 200,000 pula to damages of 120,000 pula. I hand down the reasons.
CICGB 018 of 23, Obana Wanera Muko and another, and Madisa Bohol Syndicate and 2 others.
This in your lordships, 2 answers here for the second appellant. I do hold good for Dr. Obi Susa for the first appellant.
This appeal is about the ownership of a borehole at Mutokwe, and I've penned the judgment with my colleagues Dambe J.A. and Kabanakai A.J.A. Kukure, and the result is that the appeals are not properly before the court, and order that each appeal is struck out with costs. The judge ruling is handed down.
CICGB 309 of 21, Jeffrey Bakwena and Jaime Bakwena and 2 others.
Court pleasing of the respondent, Helwa Initial City.
With Wadia J presiding, and I having authored the judgment with my colleague Kabana Kai also in the panel, the unanimous decision of this court is that one, the appeal is upheld with costs, and 2, the order of the court below awarding the first respondent the sum of 145,000 purportedly as a refund for school fees is hereby set aside with costs. And these are the reasons against in respect of the appeal.
CICGB 082 of 23, Gideon Kubula and Botswana Power Corporation and another.
In this honorable court, for the respondent, my name is for the record, Mareka, S.
This is a matter in which my brothers, Fruneman J.A. and Cameron J.A. said. The matter concerned the dismissal of the appellant and the remittal of the matter before a differently constituted, different disciplinary panel at the panel. We have considered the appeal and unanimously found that there is no merit in the appeal. Accordingly, we have decided as follows. 1, the appeal is dismissed with course. 2, the order of the High Court dated 30 March 2023 is hereby confirmed. I hand down the judgment.
CICGB 130 of 23, DSS Property Investment Company Pty Ltd and NV Enterprises Pty Ltd and 3 others.
Court pleasing for the appellants by initial letter initial S.
And if it may please the court staff, let us do A for the first and second respondents.
I presided over this matter and sat with listed the DJA and Cameroon JA. On the date of hearing, which was 23rd January 2025, the appeal was struck out on the basis that it was not properly before court, as it offends against the provisions of Section 11D of the Court of Appeal Act. These are the reasons.
CICGB 195 of 22, David Edwin Jesman and Jonga Engineering and Construction.
The respondent, initial B.
Yes. You will note for the other side, isn't it?
Yes, Rose.
Thank you. The appellant instituted action in the High Court for the recovery of money owed for services rendered. That claim was dismissed by the High Court, hence the appeal. The matter was presided over by the President of the Court, sitting with me and Cameroon JA. We find that the High Court erred in refusing to grant the claim, and in those circumstances the appeal must succeed. The following order is issued. The judgment is granted to the plaintiff against the defendant as follows: A, payment of the sum of 3.3 million. B, interest thereon at the rate of 10% per annum. C, cost of suit, and that the respondent will bear the cost of the appeal. I hand down the results.
CICGB 154 of 23, University of Botswana Academic and Senior Staff Union Ubasu and University of Botswana.
Court pleasing for the record, Shiba Pedro, initial R for the appellant.
May it please this Honourable Court, I confirm my appearance on behalf of the respondent to the matter. My name for the record is Juna, initial S.
In this matter, I have prepared a judgment in which the President of the Court, Madam Justice Tau, and my senior colleague, Lesitedi J.A. concur. The matter concerns the cessation by the University of its government index linked increases to its staff and its cessation to pay them performance bonuses. The conclusion of the court is that the appeal must fail. The court notes that it would be of no comfort to the union and to its members that the processes that have taken place at the University of Botswana in the corporatization of its structures and a separation between the emoluments paid to the Vice-Chancellor, the members of the senior management team and its professors, in contradistinction to those paid to the rest of the staff, is part of a process that has occurred also elsewhere in this region and indeed across the world. The court concludes that those structural movements are not within its power to inquire into or to change. And for those reasons, the appeal must fail. It was an appeal from the industrial court, and there is no order as to costs.
CACGB 148 of 22, Phoenix Botswana Assurance Company Pty Ltd, and the Non-Bank Financial Institutions Regulatory Authority and 3 others.
Pleasing this honorable court, I appear on behalf of the appellant. The names for the rest are Nadia Judicial State.
If this appeal is against the...
My lord, my lady, I appeal on behalf of the first respondent, standing for Mrs. Kabe.
Thank you for the speed you're rising.
Appearing for the third and fourth respondent, now the initial PU.
This appeal is against the order of the FIRA directing an insurance company to make payment to the insured for fire damage. I have prepared the judgment, and sitting with me were Dambe J.A. and Solomon J.A. is the unanimous decision of the court that the appeal is allowed with costs. The order made by the High Court is set aside and replaced with an order that the review application succeeds with costs. I hand down the judgment.
CACGB 215 of 23, Botswana Public Employees Union, and the Directorate of Public Service Management and another.
Good evening, my lords and ladies. For the appellants, my names are Ilijikae, initials AG.
In this matter, I sat with my brother Walia, who cleared the appeal, and my sister Dambe. In a unanimous decision, the result is that the appeal must be dismissed with costs, and it is so ordered.
CACGB 218 of 23, the Francis Towner Pty Ltd, trading as the Voice newspaper, and another, and Slamba Zohan.
For the appellant, Banabede Michelle.
Very pleased this court. My name is Lawrence Cooper and I appear for the respondent.
Thank you. I presided over this matter and sat with Walia J.A. and Pronaman J.A. The respondent, Slamba Tsuhani, had applied for and was granted default judgment and damages in the amount of 500,000. The appellant applied for rescission of judgment, which was dismissed by the Korako, and the appeal is against that decision. The court reached a unanimous decision, and the order that issues is as follows. The appellant's defense lacks merit and is accordingly dismissed. The quantum of damages awarded was unreasonably high and liable to be set aside. The order of the Kotako is set aside and replaced with the following order. The respondent is awarded damages in the sum of 250,000. costs of appeal and for the court appeal are awarded to the respondent on an ordinary scale. These are the reasons for the decision.
CACGB 224 of 23, Mpale Kanono Sepora and another, and the Attorney General of Botswana and 3 others.
Isn't this honorable court, I am with the OAC for the appellant.
This appeal concerns the appointment of the headman of the village. I have penned the judgment with the President of the Court and Parliament J.A. concurring. The decision of the Court is the appeal is dismissed with cost. And the judgment is handed.
CACGB 276 of 23, Alina Portia Kenny Emmanuel and Leon Christopher Emmanuel.
Pleasing this honourable court, I confirm my appearance on behalf of the appellant in the matter. My name for the court record is Juna, initial S.
And may it please the honourable court, Chief Sabile Mrs. Karma has asked me to move judgment.
I presided over this appeal, and sitting with me was my brother Debo Komabupin J.A. and my sister Ngabile J.A. The appeal relates to a dismissal of an application by the Court of Law, in terms of which an application was made by the appellant for contribution for legal costs, as well as interim maintenance pendente. The decision is unanimous, and the order of the court is as follows. A, the appeal succeeds with costs in favor of the appellant and as against the respondent. B, the order of the High Court dated 6th October 2023 is set aside and replaced with the following order. 1, the special plea of lack of jurisdiction is dismissed. 2, the High Court in Botswana has jurisdiction in respect of the divorce action between the parties and its pending ancillaries. And 3, the matter is remitted back to the High Court for the determination of the interlocutory application for contribution towards costs and interim maintenance, as well as the main divorce action before a different judge. And I hand down the result.
As the court pleases.
CACGB 106 of 23, Mine Industry Pty Ltd and Goziba Malazi.
There's no one to approve the judgment. There's an appeal from the industrial court. The issue involved in the appeal is the salary amount used for computation of compensation awarded and entitlements due. I penned the judgment. It was presided over by my sister Harukwe J.A. and the other member of the panel was Kadunde J.A. It's a unanimous decision, and the result of the appeal is that the appeal succeeds, and the order of the court of law, the industrial court, is set aside, and it replaced with an order that the respondent shall pay the applicant as follows: 5,000 kula as compensation for breach of his right to a fair pre-trial, pre-dismissal procedure. Accrued leave pay 5,000 kula 192.37. Severance benefit pay 3,461.54. withheld July's salary 5,000 and the total amount shall be paid directly to the applicant into his account at Airport Junction ABSA branch, FNB branch, sorry, by the 21st March 2025. And there is no order made for cost of the sanction. These are the reasons for the judgments.
CICGB 131 of 23, the branded clothing company Pty Ltd, trading as 088 and the Supermeric.
Might it please the ladies and lords, I have the initial J, and I appear to note the judgment in this matter.
This is an appeal against the decision of the industrial court concerning the fairness of the dismissal of the respondent. I sat with my sister, Karekwe J.A. presiding, and my brother, Deboko Maruking J.A. I've penned down the judgment in this matter. We have found that the industrial court was correct in concluding that the dismissal of the respondent was substantively and procedurally unfair, and that the compensation awarded was also appropriate. Accordingly, we have concluded as follows and made the following order. 1, the appeal is dismissed with force. 2, the order of the industrial court dated 23 is hereby confirmed. I hand down the judgment.
CICGB 002 of 23, David Van Niekerk and Gina's Point Investment Pty Ltd and another.
If the court, I appeal to the appellate for the initial case. Pleasing the Honorable Court, I appeal for the respondents Sangani T.K.
Yes, in this matter, I sat with Maruking J.A. and Liburu A.J.A. It was an appeal against the refusal of the High Court to grant the appellant an interim interdict, stopping the publication of material which he considered to be defamatory of him, pending the institution of an action for defamation. The decision is unanimous. We agree with the High Court that the appellant failed to meet the requirements for the grant of an interim interdict. Resultantly, the order issued is that the appeal is dismissed with cause. I hand down the reasons.
The court pleases. As the court pleases.
CICGB 114 of 23, Tselenga Mokele and BT Engineering Construction Pty Ltd.
Pleasing the Honorable Court, for the respondent,
Thank you. My brother, Lesotho J.A. presided over this appeal, in which I sat and I penned, together with my brother Liburu A.J.A. It's an appeal against the decision of the industrial court, and it concerns the salary payable in terms of the contract. and the computation of severance benefit pay. The result of the appeal is that it succeeds in part with no order as to costs. These are the reasons for the 5 months.
CSGB 221 of 23, we put on and another
Amagana kantsana kwa losomele motso mme ditlhogo tsa tsone di simolola ka Tautona Boko a re puso e tla tswelela e tse seemo tlhoko go bona gore ga gona dintsho dipe tse di tla diragalang mo nakong eno ya merwalela. Letamo la Gaborone le simolotse go tlhatsa mo go gomagometsang motse wa Tlokweng. Motshameko yotlhe ya ligi ya FNB Premiership ya mahelwano a beke e tlosolositswe. Motho dumela ke yona rabanteng ka lakatšhane dikgang tse di simolola ka gore go tlhalosiwa ha letamo la Gaborone le penologa mme ebile le tlhatsetsa mo mahelong a mabapi Tlokweng ke lengwe la mafelo a milweng ke go tlhatsa